Hi everybody, this is Professor Jameson. This will be the supplemental lecture to Chapter 10, The Fundamentals of Writing. Before we get into that, I want to explain kind of how you might be involved in legal research and writing when you're fortunate enough to get a job. Let's start with a big firm. Large firms are generally firms with, I would say, over 40 lawyers. Now, in a large town like San Francisco or LA, that would actually be considered kind of a mid-sized firm because there are firms with 200 lawyers in some of these big cities. But in a town like Bakersfield, where I live, 30 or 40 lawyers is considered a large firm, and there's only a few of them in town. In a large firm, the way things work is during the summer months, the bigger firms are trying to recruit new lawyers. And the way they do that is they go to law schools and they hire law students to come in for the summer, feel them out, and the basic purpose is to see what skills they have, whether, and more importantly, whether they're going to be a fit for the firm in terms of personalities, work ethic, firm culture, and things like that. So over the summer, since the law students really don't know anything, they are in charge of legal research and writing. They'll be doing things like preparing maybe motions, doing a lot of what we call legal memos, just papers on particular points of law that the attorneys need to know more about. And they're there for the months of June, July, and August. And then they go back to law school. And then what happens is when they leave, the new lawyers that they have hired right out of law school come to work for the firm. The way it works is after your third year of law school, you study all summer, most of the summer, to take the bar exam in California. It's at the end of July. And then you have to wait until usually right around Thanksgiving when you get your results. So you don't have your license to practice law. So those new lawyers that the firm has hired come to work after taking the bar, usually taking a month off after 3 years of law school in the bar. It's a month to just relax and party hard. You've deserved it. You've earned it. And then they usually come back to work in September, and they don't have their license yet, so they kind of take on the task that the law students would have taken over the summer. Okay, so a lot of legal research in the big firms is going to be done by the either the hopefully new lawyers and the law clerks. Now, if you work for a small firm or a solo practitioner like myself, I was a solo practitioner for a while. If you work for a smaller firm, say one with 5 to 15 lawyers, or a solo like I was at the end of my career, you will be asked to do pretty much anything. Okay, so you might actually have to do a little bit of legal research. They'll send you to the library, maybe find something, but no lawyer is going to expect you to be a great legal researcher and writer. Okay. Now, maybe over time you will become one, but if you never get the hack of becoming a great legal research and writer, there are other skills that you can bring to the table that will make you a successful paralegal or legal secretary. For example, solo practitioners like me, I did a lot of personal injury, family law attorneys, bankruptcy law attorneys. If you have really good communication skills, like oral communication skills, that's really helpful, because you're going to be the front line with the clients, not really the lawyer. Most of the communication with solo practitioners is going to be done through you. So if you work for a solo, that's fine. The other skill that is really important as a paralegal is organizational skills. And in my opinion, the best paralegals are the ones that can organize things. Organize files, organize cases to get them prepped for the trial for an attorney if you're a litigator like me. So attorneys, this may shock you, we're not really the most organized people in the world because we've got so much going on. So if you can organize things and keep your attorney on task, that is a huge skill, particularly if you work for a big litigation firm. But writing is important because you're going to be doing a lot of it. Okay, most of probably what you're going to be doing, and you're going to do this every day, is write letters and send them out of the office. So the first thing we're going to talk about next week is writing letters to the client, and doing things like that. And those things are really important for the reasons I specified in part one of the lecture to chapter 9, which for some reason didn't get posted. I apologize for that, but it's up now. If you have any particular questions, if you feel like you're not very good at it, don't worry. Nobody's going to expect you to be a top-notch legal writer or legal researcher. Sorry, I had a little coffee. Right out of school. Writing is like anything. You got to learn to develop it, and you get better by practice. And there's some good tips in that lecture in chapter 9, part 1, that give you an overview. So I'm not going to cover that now. If you have any particular questions about that issue or concerns, either post them or we can chat face to face online. Okay, so let's get into the chapter here. Chapter 10 deals with the fundamentals of writing, and it starts off with the writing process. And the book talks about 3 different areas of how to write. The first one being pre-writing. Okay, most people who are beginning writers do not spend enough time in the pre-writing process. And what does that involve? It means, think about, who is my audience? What am I trying to communicate here? What is my goal in producing this particular piece of paper? Okay. The best way to start pre-writing is you can brainstorm, just get your ideas down. You can create an outline, whatever it might be that you feel comfortable. Okay. So a lot of people just sit down and start writing. Now, I'm going to be honest with you. I do a lot of what I call stream of conscious pre-writing, where I tend to dictate things and have my secretary type them out, or I used to. Sometimes I'll type them myself, but I like to just get things down on paper, and then I can go back later and revise them. Okay, that is not the way I recommend that you do it. Okay, I recommend that you start with an outline. You think about the issues, what you're trying to communicate, and things like that. I would not recommend that you just sit down and start writing. Okay. Now, I tend to be actually a good writer. Okay, that's why I was a good lawyer. I started out my career in wanting to be a journalist. Did a lot of journalism in high school and in junior college, and so I have a lot of experience writing. It tends to be easier for me than most people. Okay, which kind of makes people jealous, but be it what it may. One of the other important things in the pre-writing process is making sure you've done your legal research and you've got your ducks all in a row. Now, what's going to happen sometimes is you're going to start writing, and then what's going to happen is you're going to realize you're going to have to go back and do a little more research after you put some thought in it, and that's okay. But the more that you do up front in terms of note-taking, having the law in front of you while you're doing your writing, will definitely. Now, when we're writing things like legal documents, and when I say legal documents, I mean a legal research memo, a motion, a trial brief, an appellate brief, whatever it might be. The book suggests that you develop what we call a thesis, okay? And a thesis is a central idea, okay? Something that's going to kind of run through the whole document, okay? What is this document about? What am I trying to prove, okay? In terms of a thesis, it's like a theme. Okay, maybe you might think of it more as like the moral of the story. Okay, it might be that our client is being treated unfairly, or the law is on our client's side and we should win. Whatever it is, okay. But there should be some central idea, or several central ideas if we're writing a long document, and keep that in mind when you are writing something like a law office memo. What is the main point that we're trying to get across? And try not to lose, the next section of the book talks about, and I'm not going to talk particular page numbers because we have different versions of the book, talks about the structure and overall organization. Okay, a good organization is essential. Okay? We have to make it easy for the reader to understand what we're reading. And the easiest way to do that is to use headings. Okay. When I try, for example, to write a motion, my goal, and we'll talk about motions later in class, my goal is for the judge to be able to read just the headings themselves and understand what my argument is. And if you ever have to write a legal research memo yourself, I suggest you do the same. If I ask yourself, if I read these headings and just read these headings without looking at the actual paragraphs, could I understand what my argument is? Okay. Headings are important. A lot of people, you'll be surprised, only read the headings. Okay, I will briefly talk here about the organization of an office memo, or what we call a legal research memo or a law office memo. You're going to have to follow what we call the standard IRAC formula. Okay. Sometimes, if it's really long, we'll start with a summary of the facts. I like to think of it sometimes as FIRAC. So we'll start with a summary of what our facts are if we're working on a particular case. We'll know what those are. Okay, what our client's situation is, whatever it might be. And then the next part of the memo will start with an issue. The issue is what is to be decided in the case. Okay, for example, an issue might be, does a policeman need a warrant to search a car when they pull somebody over? And if not, what are the exceptions? Okay, that might be an issue. Okay, a lot of times we like to work the facts into the issue. Don't worry about this stuff later. We're going to get into law office memos and stuff in a couple of weeks. I'm just kind of, for consistency's sake, going over the what's in the book in this chapter. Okay, so we'll deal with that in more detail. Okay, after the issue, we have to find the rule. Okay, now where do we find the rule? Well, in our legal research. Okay, the rule is the rule of law. Okay, it can be a statute, which is a law passed by the legislature. It can be a case, which has been decided by a court. Okay, remember, but from legal research right away, the case has to be controlling or on point. Okay, which means the judge usually has to follow it, and if not, we'll tell him that he can follow it, which is what we call persuasive authority. Okay, so there's the issue, there's the rule, and then the application. Okay, and this is the part that most people skimp on because it's the hardest. Okay, the application is where we take the facts of our client's case and apply them to the rule of law that we found in our legal research memo. Okay, so this is where we analyze the facts. Okay, and if we're doing a law office memo, we're going to do it in a neutral manner. If we're doing it for a court, we're going to probably put a little bit of a spin on it to make our client's case seem the strongest as possible within the rules of being ethical and fair. Okay, so issue, rule, application, and then conclusion. Well, what's the conclusion? The conclusion is going to follow from your application. After analyzing the facts of the case and applying the rule of law in the analysis section, then you'll come to some conclusion. It might be that our client is a slam dunk loser, our client's a winner. This could go either way, but it will come to some type of conclusion. Okay. Now, with that being said, this is a difficult process. Okay. Lawyers spend 3 years, or law students spend 3 years in law school just trying to be able to accomplish this. And so don't get all freaked out if you feel that you're uncomfortable. You should be uncomfortable with this. It is difficult.